Thank you, Judge. And I'll have that order circulated to your email, so please be looking out for that in the next hour or two. Um, and that will be in your email via DocuSign.
Okay, thank you.
Thank you very much.
All right, Mr. Dunn, which one is yours?
Your Honor, I have several, but the one I was going to request the court to hear was
Well, I only got two up here right now, so several might be in the works, but which one you got now?
yes, Your Honor. If the court would hear Coriel 56806.
All right, yep, that's the only one Coriel up here. So at least I think it's only one. Yeah, it's only one. And so this ought to be it, 56806. Okay, that is. All right, are both parties present?
Yes, Your Honor. May I go get them?
Yes, you may.
Thank you.
Yes.
All right, Mr. Dowers, we'll be right with you in just a moment. Thank you. Everybody ready? This is Mr. Johnson and Ms. Dowers. So y'all need to unmute yourselves and turn on your videos, and we'll get started. Okay. If you can't turn on the video, as long as I can hear you, that'll work. So let me go ahead and start the recording. All right, we're now recording, and this is Coriel County calls number DC-25 56,008.06. This is in the interest of Johnson, minor child, non-custodial party being Destiny Dowers, custodial party being Keith Johnson. And this matter is before the court on a Uniform Interstate Family Support Act petition, UIFSA. That was a request from a sister state for us to get child support on a Texas resident. Anyway, the court will know for the record that Ms. Dowers signed a waiver that's been back on file since the 5th day of May. So that's been back on file long enough. So we're properly before the court with the notice requirements as set forth by the Texas by the Texas Rules of Civil Procedure. Anyway, I know for the record that both parties are present. And again, since this is a UIFSA matter, the only thing this court can deal with are the issues dealing with support, and I'm limited to the items requested by the referring state. So at this time, I'll ask the state for an opening to tell the court what the state is requesting we do here today, whether or not you requesting this to be a final order, and what request did the referring state make? I know it's usually always child support and health insurance most times, and sometimes retroactive. So what's the referring state requesting, sir?
Your Honor, the referring state is requesting retro and current. They're requesting cash medical reimbursement, cash dental reimbursement. And that's what we filed for. But I don't know that the retro is going to be appropriate in this case. I believe it's all in the interstate packet, Your Honor. But basically, originally a Florida court made mom the primary, or gave custody, or however Florida calls it, and Florida courts ended up flipping. Then they referred to us to get the child support started on mom. So dad's the primary. But based on that, I don't believe that the retro is appropriate. But obviously, I can present that information if the court believes it is.
I just need to know when they did the flip, and that control was it's going to control what we do here one way or the other. But I'll see about it. So,
I believe it was
all right,
2022 or 2023, Your Honor.
2022.
Okay. Just good folks, do not interrupt another person when they're speaking. You'll get your chance to tell the court the information, or while anyone else is speaking or anyone else is giving testimony or making a statement. You cannot interrupt them, even though you know the answer and they may not. But anyway, we'll get all that straightened out at this point. So I'm going to go ahead and swear both parties in, and we'll get started. So, Ms. Dowers and Mr. Johnson, both please raise your right hands and unmute yourself. All right.
It's not allowing me to turn my camera on.
Okay, just raise your right hand then, ma'am. Thank you. Do both of you solemnly swear or affirm the testimony you're gonna give here today is the truth, the whole truth, and nothing but the truth so help you?
Yes,
do.
sir.
All
I
right, you
do.
both agree to swear under oath. I'm gonna go ahead and let the state call you both as witnesses. You can put your hands down. And if there's anything either you think I need to know that's relevant to what we're doing here today, child support, cash medical, dental, and retro, let me know, and I will go ahead and let y'all get that information before the court again, so long as it's relevant. So at this time, I'm going to go ahead and have the state. I'll call your first witness, please. Thank you.
Thank you, Your Honor. I'll call Mr. Johnson. Will you state your full name, please, sir?
Keith Dion Johnson.
So let's talk about the procedural history. Who originally was the primary conservator? Like Florida probably uses different terminology. Who originally had custody?
The mother had custody until July 2022.
Okay, and in what state? With the court of what state awarded her custody originally?
It was in Florida.
Okay, and was it Florida, Texas, or a different court that flipped the custody and made you the primary?
Yes. Once she went to Texas, Florida.
Okay. So let's talk more about the particulars here. The interstate so the packet that Florida sent us requested medical support in the amount of $107 and dental support in the amount of $15. So do you have any objection to me requesting the court to use those numbers in the order that's going to come from today?
No, I don't have no objection.
Okay. And then I believe the evidence is going to show that Ms. Dowers makes approximately $2,800 a month. And I believe she has one child living with her. Does that, you may not know how much she makes, but one child living with her, does that sound correct?
Yes, I believe so.
Okay. So assuming those and assuming the medical and the dental I've given you, the child support would be $402 a month. The current child support would be $402 a month. Now, do you have any issue with me asking the court to use that number?
No, I don't have an issue.
Okay. All right. So in my understanding is that you are asking the court to order retroactive support today. Is that correct?
Yes, sir.
And it sounds like there's been some other facts of this case that you're asking the court to consider. Is that right?
Yes, sir.
Okay. Can you in a couple sentences kind of tell the court what happened and how the child came to live with you?
Well, the child came to live with me because we was going through a custody battle, and during that custody battle, she just left the state. The judge signed a pickup order, and that's how I gained custody of the child. Since July of 2022. Since then, I have not received any funds from my daughter. I was still paying child support. I think a year and a half after I had my child, and yeah, that's pretty much what happened. So I've had my child since July of 2022, and I haven't received no funds from her at all.
All right, real quick, sir. What was the original order for custody out of? Where was that located?
That was in Florida.
Same same county or another county?
Same county, sir.
All right, thank you.
And like I said, the lady from Florida, she basically said that.
Stop. Here's the deal, sir.
Oh,
You can't testify to something someone else said, okay?
okay. Well, I apologize. I don't know.
It's okay. I know you're not a lawyer, but that's hearsay. I know you heard that
Okay.
too.
Okay. Well, yes, sir. So, well, then that's basically it. So I was just asking for retro pay because, like I said, the child is both of our responsibilities. I've been paying medical, and she's after school programs and things like that. I've been doing that by myself, school cheerleading,
Okay.
and
All right. In other words, you're being dead. Got it. Yeah, that's the norm. That's the kind of stuff. People think kids only they only eat, sleep, and you gotta work and you gotta feed them. Nah, it's not even close. But anyway, I'll go ahead and let the state ask the next question, please. Thank you.
Thank you, Your Honor. And I'm backtracking a little bit here, but Mr. Johnson, how do you have insurance for your daughter? Is it through work or is it through another source?
to work.
Okay. And my understanding is that Miss Dowers was served in May of this year. Do you have any reason to believe why she might have been trying to avoid service or trying to avoid this lawsuit?
Okay. Mr. Johnson, she signed a waiver.
Okay, I retract. I withdraw the question then, Your Honor.
All right, thank you. Yeah, she signed a waiver, and that's the date I gave. That's the date of the waiver I gave already. Thank you.
Yes, Your Honor. All right, I will pass a witness, Your Honor.
All right, sir. We'll be back in just a moment. I'll go ahead and let the state call your next witness.
I'll call Miss Dowers, Your Honor. Miss Dowers, will you state your full name, please?
Destiny Dowers.
All right, and let's talk about what you do for work. Where do you work currently?
I currently work at a youth center on Fort Hood as an admin assistant.
Okay, and what do you make an hour?
$21.54.
All right, and as I understand it, it's 30 hours a week. Is that right?
Yes.
Okay, so it's the same questions to you. I calculate your gross income at $2,800.20 based off of $21.54 an hour and 30 hours a week. So I would set the support at, or I would request the court can do whatever the court wants to do, but I would request the court to set the support at 402 on the child support, 107 on the medical, and 15 on the dental. Do you have any objection to any of those numbers?
No.
Okay.
Well, with the child support amount, because I don't even bring in that much after you do the net income.
Yes, ma'am. I understand.
All right, ma'am, the calculations are based on what the state determined your net income to be based on taking out Social Security, Medicare, and income tax. And we have the calculators for that, and there's a chart in the family code for that. So whatever we only look at what the government's taking out for the government. Anything else coming out will not be counted. Anything else extra you got coming out can't be counted.
Okay.
So again, man, according to the United States of America, ma'am, that is technically your net income. State of Texas, that's your net income.
Okay.
All right, thank you.
And Miss Dowers, I take it you're not in agreement with retroactive support?
Correct.
Okay. I will pass the witness, Your Honor.
All right, ma'am. At the time the child went to live with dad, or the court gave him custody, were you in Texas then?
Yes.
Okay.
I relocated June 2022,
All right.
and I didn't know I had to get approval to leave.
Okay. All right. Any other questions of this witness, Mr. Dunn?
No, Your Honor.
All right. I'll start with you, Mrs. Dowers, and then go to Mr. Johnson. Is there anything else, ma'am, you think I need to know? Again, this is kind of just a mathematical formula. You plug in the numbers and it comes out at a certain amount, and I need to take it from there. But the bottom line is, I hadn't had a chance to review the entire packet from Florida yet, so I want to double check everything. But I'm sure Mr. Diamond is correct that the state requested retroactive child support. And under Texas law, that's something I can order. So, ma'am, based on that, is there? I understand you don't have a problem with the child support going forward, but with the retro, do you have any type of statement to make at this time?
Well, I've supplied over like $3,000 in transportation costs getting her from Florida here and back.
Okay, ma'am. You mean for visitation?
Huh?
You mean for visitation?
Yes.
Okay, ma'am.
Everything was at my expense because we were still going through the court battle. They didn't make it final until February of this year.
Okay, all right. I'm sorry, the court, the final order was not granted until February of this year?
Yes.
Okay, all right. Do we have a copy of that? Is there a copy of that in the file, Mr. Diamond? I thought I saw some of the stuff, but
I thought it was in the packet, but if not, if it's just loose, I can send it to you,
okay,
Your
let me
Honor.
double check it. Let me double check it. Okay.
Oh, it may not be in the packet, Your Honor.
There is some stuff here in the file. Let's see. Here we go. Certified copy, not a certified copy, not a certified copy. That sounds like court stuff. Here we go. I got it. Yeah, they want the states to have a parity plan. All right, here we go.
So actually, Your Honor, it may have been a subsequent it looks like the most recent order we only received in February of 2025. I can send this to Miss Molina if you'd like, Your Honor.
Okay, let's see what I got here. Let's see when this one was signed. All right. Oh wow, Henry. Boy, that's a small type. Done in Northern Chambers on the second day of August 2022. You say you got a more recent order than this one?
Uh,
What's the date on the order you have, sir?
well, we received it in February of 2025. It looks like. Let's see what the sign date is. This case went up on appeal, and so it came back on a remand.
Okay, what up? Okay, that's new.
It looks like January 24, 2025.
Okay, so you said it went up on appeal to the Court of Appeals in Florida?
Yes, sir.
Okay.
But it looks like January 24, 2025. I'd call it the sign date, but their judges don't sign stuff, they stamp stuff instead.
Okay. All right, Mr. Johnson, what did he go up on appeal for?
Oh, well, she did the appeal. She was basically trying to say that my daughter was failing in education, which the courts determined that wasn't true.
All right.
That's why I still have custody.
Okay. All right, send that order over, Mr. Diamond. I need to take a look at it.
Yes, Your
All right,
Honor.
and while this was going up on appeal, were there any interim orders, folks? Mr. Johnson, were there any interim orders?
Well, intro orders?
Yeah, while the appeal was pending.
No, so everything remained the same. I still had custody. She still got her Christmas
Visitation, I got it.
and summer. That was it, sir.
All right, I need to see a copy of the new order to see what I can do one way or the other. All right.
Yeah, and Your Honor, and maybe the court probably already understands this, but just to be clear, I kind of danced around from it. My agency probably should have filed this as a motion to set support rather than a motion to establish. But I don't think that's a fatal mistake. I don't think the retro is appropriate, despite the fact that we filed for it. But yeah, I'm sending that right now, Your Honor.
All right. All right, is there anything else, Mr. Donovan?
I could summarize if the court wants to hear it, but that would be all I'd have.
All right, then. Well, I'll just make sure there's no other witnesses. So I'll tell you what, let's look at, I'm gonna go ahead and let the state make a closing statement, folks, and then I'm gonna give both of y'all the opportunity to make a closing statement. And I'm gonna have to see what this final order says and balance it against the other order and see what I can or cannot do. So anyway, Mr. Diamond, I'll ask you to close the statement and what's your theory is on why the court why you don't think that retro is appropriate based on these circumstances. Again, I've never had obviously a case where there was a Court of Appeals case pending in another state. I've had them here, and there were always interim orders while everything was on appeal, and so that made it easy. So, but I'll take a look at it, and yeah, 'cause I can see how that'd be problematic because I got a new order that was finally signed by the court. And it sounds like they may have had the jurisdiction to do their own retroactive child support at that time. So I definitely need to see the order. So let me hear you state. Let me hear you close it, sir. And then I'll go to Ms. Dowers and then to Mr. Johnson. Thank you.
Yes, Your Honor. So the emails is sent to Ms. Molina, but it's that, Your Honor, that this is not an original order, even though we pled for to establish. Really, what we were pleading to do was to modify and set support, or believe that's what we should have been seeking to do. But again, I don't think it's fatal because either way, we're asking for mom to pay child support. So that would be my theory, Your Honor. The requested amounts would be 402 on the child support, 107 on the medical, and 15 on the dental. Miss Dowers signed the waiver, I think May the 2nd of this year. So I know the court typically starts, the earliest the court would be willing to start would be the first of the month after. So that'd be June the 1st. I think it'd be fair to Mr. Johnson to start the obligations June 1, 2025. And I guess the court didn't hear a whole lot of testimony about disagreements over the back and forth of reimbursement for travel or things like that. But my opinion is that that's a Florida issue. They can go to Florida and fight that out if they need to.
That's a visitation issue, and I don't have jurisdiction over that. So that's
Yes,
fine.
yes, Your Honor. Anyway, that's all I have, Your Honor.
All right, sorry. It's a visitation issue that can be taken up by the Florida court, and because I did note that they said they didn't. They technically held an abeyance to a further order on anything concerning travel expenses. So I guess they can go either way. All right, Ms. Dowers, any type of closing statement, ma'am?
No, sir.
All right, Mr. Johnson.
Yes, sir. To my knowledge, there's no order for retro pay. Like I said, Your Honor, I was paying child support a year and a half after I got custody of my daughter. So that's why I believe that it is necessary for retro pay. I've now had her for 3 years with no help. Every time I asked her for something, she referred me to saying that child support, get it from child support. So that's why.
All right. Well, sir, obviously I'm going to go ahead and order the child support, cash medical, and dental as requested. I'm looking to probably start it the first day of June. That's under Texas law. You start the first day after notice of service and or waiver. What I've got to figure out is based on these two orders I got here, whether or not I have the authority under Texas law to order retroactive child support. Because again, I've been doing this for 20 years and I never had this happen before. I don't think I never had it. I know that obviously some cases were appealed, but the appellate circumstances never came up in my hearings. So I've got to see what both these orders say, and I might have to do a little research on what Texas law says I have to do, one way I can or cannot do. But I'm going to try to see if I'm giving you some form of justice there. If I can't do anything, I'll let you know. If I can only go back to the second order, the first of this year, I'll let you know. But for right now, I'm going to go ahead and order child support to start the first day of June. So, ma'am, obviously, we can go back that amount. So you owe that amount. And the next amount coming up will be due the 1st of August. And I will go ahead and I'm going to make that's going to be the final order court as far as support is concerned. Mr. Diamond, this was going to be a little bit more complicated than I thought. So what I want you to go ahead and do is do a temporary order setting up the child support starting the first day of June. And what I want you to do is pick a date in late August for us to come back on a reset date. So I got the opportunity to read the entire file on this one. I got to look at the EUFSA packet. I got to look at the original order, and now I got to look at the second order. And that's about a total about 50 pages worth of reading the judge has to do. And that's my job. I'll do it, but I'm not gonna shoot from the hip after a 30-minute hearing. So what I'm going to go ahead and do, folks, is I'm going to go ahead and make the child support and the cash medical and dental the order of the court. I'm going to do that as an attempt, and I'm going to have the state reset this matter for me to make a ruling on retro. And I'm going to try to get you folks in one of our dockets in late August, because right now I know we're pretty full in early August, and that way I can make a ruling on that one remaining issue of retroactive child support. So, yeah, Mr. Diamond, I'll actually make that attempt. And so at this time, Ms. Dowers, any questions?
No, sir.
All right, Mr. Johnson, any questions, sir?
Yes, I have one. Will it be sent to my email when the docket?
The state's going to send you a copy of the temporary order by DocuSign, and they're going to send you a copy of the reset order and it'll all be through email. But they're two separate documents.
Okay, sir. That's it.
All right, then. Like I said, we're going to go ahead and start with child support, and I'm going to go ahead and do some reading here, guys. Is there anything else, Mr. Diamond?
Your Honor, I'm looking at the late August. It looks like there's some of your discretionary slots on August the 28th. So maybe we use that date.
Okay, let's go with baby girl's birthday, 28th of August.
Thank you, Your Honor.
All right. Yeah, August is a bad month for birthdays in my family. She's the last one of about 15. So yeah. So, all right, folks, we're going to reset this for a Zoom docket on the 28th. You'll be getting that Zoom code in a reset order, or it'll be part of the temporary order that you will receive starting the child support. And ma'am, please remember, under Texas law, you're not in trouble for not paying June 1 and July 1. But child support's due the first day of the month. And if it's not paid by the last day of the month, you're in violation of the court order, and the state has the option at that point of filing a motion to hold you contempt, and you definitely don't want that to happen. So anyway, but that's just to give you a heads up. All right.
Will it be taken out of my paycheck?
They'll probably send it out eventually, man. But if it didn't, you see your paycheck, you'll see it coming out. It's child support. If it's not coming out, you got to pay it yourself personally.
Okay.
So, and you can go to the Attorney General website to do it personally. You can go to any Walmart or CVS pharmacy and do Western Union, do a MoneyGram. It's only a couple of dollars, and that goes to, and just use the OAG number at the bottom of your where your name is on the father, and your name is right there on the top page of your any pleading in this case. On page 1, there's an OAG number. You give them that. You always paying your child support. And like I said, you can do it online. You can do it that. But again, make sure you pay that only before midnight, the 31st of August. Otherwise, you're technically in contempt of court, man.
Okay.
And technically contempt is 180 days Corio County Jail. So yes, ma'am. Take care of that, please. Thank you. All right. Anyway, guys, I'll see y'all all, but I'll see you both back on the 28th at 9 a.m. We're going to try to get you guys in as early as possible, and I'm going to go ahead and make myself a little note on that code, Zoom code, to remind me. Yeah, but I'm gonna try to. The state's gone to their conference next week, so I'm hoping to get a chance to read everything on this next week, and I'll have Belinda bring it to me so I can read all this documentation. So. I'll have the state want them to sit around in a break room until you get a temporary order ready, or are they free to go?
If they could be released, Your Honor, I've got 2 more hearings I was going to request, so I don't. It'd be a while before I could get to them.
All right, Mr. Johnson, Ms. Dowers, y'all free to go, and I'll see you in about what's the date? 22nd. So I'll see you in 37 days. All right, 38 days. Thank you.
Yes, sir. Thank you.
Thank you. Belinda, you want to come grab this and put this in a folder for me, where I can keep it separate? Because like this thing's gotten kind of thick now. All right, what you got next, Mr. Diamond?
Uh, I hate to do this, Your Honor. I have
I'm still waiting
it
for
looks
the
like
impact.
the hearing worksheet shows that Mr. Gwynn has a hearing. Um, it'd be a Bell County case, so if he has that, maybe he could go. Because
I'll go talk to him.
All right, right
would
now,
you?
the only file I got up here is Bell County 345-845.
Okay.
That looks like a jail, okay, Melissa.
It is. Could we maybe take that one up, Your Honor? I've got another one with parties, but I've got a question of the CSO who negotiated the case with parties. So, and
Okay.
the one that the court has should be fast.
All right, Mr. There.
About 4 years now, 4.
So, Your Honor, I don't see anything in on Zoom in September. Kurt's set to be before you on October the 28th.
Okay, I'll tell you what, let's pick a date in mid-October that's not too crowded. I mean, mid-September that's not too crowded. Let's not kick this down, kick that can down the road that far.
So we have there's not I'm not trying to be difficult here, Your Honor. There's